Yes.
Dobro večer, dragi forumaši. Good evening, dear students, dear friends. It is my great pleasure tonight to announce our guest, our first foreign guest in this semester, Dr. Thomas Gobbitt, who is a researcher at the Medieval Studies Research Institute of the Austrian Academy of Sciences, who also occasionally teaches in various universities in Austria, who is an expert on medieval law. As you see, he will be talking about Lombard law tonight, but who is a man of many talents, whom I met on a conference when he was talking about medieval elements in tabletop horror RPG games. So if you have any pop culture questions, he might be able to answer those as well, particularly if they're related to poisoning, which might be a special interest of his lately.
It's been a long-term interest.
So, Tom, they're yours, don't poison them. Beyond that, do whatever you want.
I will try not to poison. Thank you very much for the lovely introduction. I'm just going to run through this. If I get excited, I will start talking quicker. If I start talking too quickly, wave, shout, or anything you like and get my attention and tell me to slow down. But I'm talking about a subject I love, and you know how it gets when you love something. So if I'm too fast, just let me know. Okay. So my aims in this paper today are to examine the development of the early medieval Lombard laws from the 7th century, when the first written Lombard law code was issued in the name of King Rothari, through to the flourishing of Lombardist legal studies in the long 11th century. And with a quick look at the continuing study of Lombard law in the university law schools from the 12th to 14th centuries. As the title of my paper suggests, I won't be looking at the entire law code, as we've already mentioned. We're going to be focusing on one specific legal theme, poisoning, because it's fun and we deserve it. Some general observations for context will, of course, be useful, but I'm mostly going to focus, like I said, just on that. So, the paper is going to be broken down into, am I in the way? 3 main parts. Firstly, some introductory comments, in which we take a first quick review of the scholarship to establish the general development of attitudes to poisoning as a crime across the early medieval period. I'll then turn to the development of the Lombard laws themselves across that period, as despite the Lombard rule in Italy having lasted for a little over 2 centuries, from their arrival in 568 until the Carolingian conquest of northern Italy in 778, and all of the laws having been issued between the mid-7th and mid-8th centuries, manuscripts containing copies of the laws continued to be produced and used, updated and augmented from the 7th century all the way through to at least the 14th century. In fact, I'm reliably informed that the Lombard law remained in force in Benevento up until the 17th century. So this isn't exclusively medieval. This keeps going. Our knowledge of the rise of Lombardist legal studies is primarily from glossars, commentaries, and other scholia employed in these manuscripts from the 11th century onwards. So as we follow the timeline, we'll then take a closer look at the specific laws in question, those in the Edictus Rothari, issued in 643 CE, the first written Lombard law, and then in the editions of King Liutprand from the early 8th century. Following a brief overview of Carolingian capitularies, we'll then turn to a case study of Lombardist legal scholars in the 11th century and conclude with a capitulum of the Etonian Emperor Henry II, issued in 1056 CE. So, the main terminology used to refer to poisons and poisoning in the medieval periods are basically variations on veneninum or veneficium, so poison, poisoning, and of maleficium, magic. And within many of the laws, especially outside of the Lombards, across the early medieval Leges Barbarorum, these terms are frequently used interchangeably. As Marianne Elsakers argues, this inseparable intertwining of poison and magic in the Leges Barbarorum, especially the Frankish law, shouldn't be taken as confusion on behalf of the lawgivers. It is literally because for early medieval people, there is no difference between poison and between magic. In both cases, they involve the preparation of a potion that the victim must then drink. And while magic is implied, first and foremost, maleficium has to do with dangerous herbs. Some laws and capitula make direct reference to poisonous plants, herbae, herbs, stirpus, roots, others to the modes by which the poisonous substance was prepared and administrated, whether just to drink, possibly offered to the victim as a toast, or specifically naming its preparation in a poculum, a drinking cup, or else as a potione, a potion. So in the modern day, we generally assume that the medieval attitude to poisoning was it was considered to be an inherently nefarious and secretive crime. This perspective is reinforced by the association of poison with magic, as just mentioned, as well as the way that to deliberately get an unwilling victim to take poison, you've got to be devious. If you don't want to be poisoned, and you know it's poison, you're not going to drink it. So also, the effects of the poison on the body, mostly causing damage to internal organs, might not be visible either. So the potential for poison to be secretive is obviously very obvious and at the forefront. And previous scholarship has also demonstrated the nefarious, the evil side of poisoning as well, at least from the Carolingian period onwards. And throughout most of the Middle Ages, poisoning is just described as the wickedest crime, a form of treason. But when we go back to the very early Middle Ages, to the Leges Barbarorum, things, as Frank Collard points out in his incredibly useful Crime of Poison in the Early Middle Ages, things get a little bit more muddled. And in fact, he describes the early medieval attitude as being about the most objective view on poison that we find in the Middle Ages. And by objective, I think he means impartial, possibly even unemotional. It's just described in very literal terms. Now, the Leges Barbarorum obviously did not originate out of nowhere, and considering the audience, I'm going to make a very quick mention of these and not go into too much detail because I'm not a Romanist. But prior to the early Middle Ages, the two main pieces of Roman law which addressed poisoning as a crime, of course, Sulla's Lex Cornelia and Antonin's De Maleficiis, both of which are transmitted in various forms inside the Leges Barbarorum. And also some of Paulus's Sententia are also included in the Visigothic laws far to the western Spain. So it's not that there's a sudden break. It's not that the Leges Barbarorum are coming from nowhere. And it has previously been argued that even the Lombard laws that we're going to see may even be an expansion of Sulla's Lex Cornelia. So within the Lex Cornelia, we find beneficiis, poisoners, being associated directly with sicari, assassins or murderers. So we already have a direct link here between poisons and secretive intentional killing. And the nefarious associations are further expanded by the body of the law, also including causing death through perjury or by legal officials accepting bribes. Article 5 of the Lex Cornelia gives details of what it means to be a benefici, a master of poisons, which includes the acts of possessing, selling, or preparing poisons with intent to kill. The intent of how the poison is to be used is paramount here, and it should be remembered that in Roman law, poisoning is separated from killing by ordinary means on the grounds of whether or not physical force was used, rather than the specific weapon or mode in question. And therefore, poisoning and hired assassins, etc., are brought together as different types of crime in a list whose underlying similarity or severity is basically emphasized by the punishment applied to them, which is deportation. Moving forward in time to Antonin's law on maleficiis, poisoning gets placed, like I said, alongside magic or witchcraft and alongside mathematicus, so astrology and divination and other such crimes. So the placement of poison, to quote Collard again, now marks the connection of this crime to legislation against evil spells. And moreover, the poisoner leaves the orbit of the hired assassin only to enter that of astrologers and witches. But overall, both of these associations can arguably be seen as different types of nefariousness. So we would expect, perhaps, if we see the early medieval Lombard, Leges Barbarorum, barbarian laws as a continuation, we'd expect that secrecy and nefariousness to have come through directly. However, the Leges Barbarorum address poisoning in a variety of contexts, some of which are nefarious, some of which are serious, secretive, many of which are not. Most common, of course, are laws punishing the preparation of poison with criminal intent. the actual administration of poisoning and whether the victim then survives or dies. Some laws focus on the mode of poisoning, whether by preparing herbs or as a drink to be given to the victim, as mentioned before, while others include mention of the use of poisoned arrows. Other laws consider the relationship of magic and medicine more closely, especially when they go wrong, and injure or kill the person who is supposed to be being treated or healed or bewitched. It kind of resonates with Paracelsus' statement from 1,000 years later that it is the dose which makes the poison. It appeared that the writers and compilers of various laws in the Legis Barbarorum were building from a somewhat similar idea. Sometimes it's medicine, sometimes it kills you. Don't go to an early medieval doctor. Other laws address the legal process for pursuing accusations of poisoning, whether in relation to false accusations or as a means to an end, particularly in the case where a proven accusation of poisoning or grave robbing or adultery were the only grounds for which a man could divorce his wife in the Burgundian laws. Across the 7th to the 9th centuries, the Frankish hegemony, the Frankish Empire, Carolingian Empire, expanded, particularly under Charlemagne, Charles the Great, who was king from 768 and emperor from 800 and died in 814. As the empire expanded, when other kingdoms were brought into the Carolingian Empire, they continued to use their own law, including the Lombards, following Charlemagne's conquest in 778, and in places which did not already have a written law code, they were compelled to produce one. Often those newly written law codes of the Legis Barbarorum primarily denote where their laws and customs differ from the Frankish law codes. The Carolingians also furthered regulatory change through the issuing of capitula, broad-ranging term used to define a wide range of legislative and normative texts, from promulgations of the royal court and directives to missi and scabini, so royal legal officials, through to the memoranda and agendas arising from episcopal councils, synods, etc., etc. So Carolingian officials and intellectuals produced a wide range of texts as well, chronicles, books of history, poetry, reflections on the nature of God, society, what their duties were. And through all of these, we see a sudden and dramatic change of attitude towards poison and poisoning as a crime. So on the one hand, poisoning and poisoners are increasingly being understood in Christian biblical terms, and the association of poisoning with pagan magic is reinforced. On the other hand, we now see it being defined, as I said before, in superlative terms. At the Council of Tribur, held in 895, the use of veneno, along with herbae and other maleficia, are described together as pessimis homicida, the worst kind of killing. So this attitude persists throughout the remainder of the medieval period, with poisoning becoming considered a form of treason, and the demonstration that a person was killed by poison itself now being taken as direct evidence that the killing was a premeditated murder. An indication of sustained malignant intent on behalf of the perpetrator as they went through the various steps required to obtain and prepare a poisonous substance and then administer it to their victim. Frank Collard notes, in the medieval period, poisoning does not have a discrete identity as a crime in its own right, however. Instead, it's always mixed in with other crimes, usually either magic, as said, or just as another means of inflicting injury or death. In the university legal studies as pursued in the late medieval period, this is highly apparent, the perspective already seen in the Roman laws discussed before, and these have taken centre stage once more through their incorporation in Justinian's Codex, and within the Corpus Ius Civilis. It's only towards the end of the medieval period that poisoning and magic begin to become unentwined and begin to become crimes in their own right. So with that overview in mind, let's turn back, finally, to the Lombards and the development of their laws and legal attitudes to poisoning as a crime. So a group of people, known as the Lombards, or at the time the Langobards, came from Pannonia into Italy in 568 CE, led by their then king Alboin. At this point, the Lombards did not have a written law code of their own, and the regulatory aspects of their own social structure were primarily organised through customary practices and oral tradition, called in later texts by the Langobardic term "cauafade," custom. In older scholarship, it used to be assumed that what was identifiably Germanic in the laws must have been ancient practice, and what appeared to be derived from Roman sources must have been contemporary introductions, amending and augmenting those ancient practices. But as Walter Pohl has pointed out, by the time the first law code was written in the mid-7th century, the Lombards had already been in close contact with the Byzantine Empire for the better part of a century, mostly doing mercenary work for them. And even if they did not have their own written laws, were well used to working within and alongside a culture of legal literacy. As Pohl observes, it's very likely that many Roman elements in the Lombard laws had already been handed down orally and transformed through that period, while apparently Germanic elements were as likely to be contemporary innovations. In short, we cannot neatly align German and Roman with oral and written, nor with ancient and novel approaches. Most importantly, therefore, we must remember that Caufade does not simply comprise some kind of ancient and unchanging Germanic folk practice. And we're already looking at systems that informed through use, repeatedly developed, recontextualized in the moment of their application. Oral society is immediate. Written stuff updates a bit more slowly. Moreover, these structures are deeply inspired through broader contacts, not just with other early medieval gentes, so peoples and polities, but also with a range of religious and legal frameworks, especially Christianity and the Lombard's ongoing interactions with Roman law. Obviously, we do not know what the Lombards specifically thought about poison, especially in regulatory terms, in the period prior to the writing of the laws. We do have a few historiographical references to actual poisonings amongst the Lombards, but the surviving accounts are all either written by authors outside of Lombard Italy, or else were written sometimes centuries later. So most notably, we have multiple accounts of Queen Rosamunda first conspiring to kill her husband, the same King Alban who brought the Lombards into Italy, and then later poisoning her co-conspirator before then being forced to drink the rest of the potion herself, fatally. Paul the Deacon, writing in the late 8th century, about 2 centuries after the events he's describing, sees her death as a fitting punishment for the crime. But it's surely a poetic punishment rather than a legal one, as in the Lombard laws, restitution for poisoning was set with a monetary compensation, especially if the perpetrator was free, and the death penalty was only named for enslaved poisoners. And a queen, even one who was first captured in war and forced into marriage, is still a queen and is as far from an enslaved person as Lombard society and law could imagine. But those are all reflections of one of the great intellectuals of the early Carolingian era, and as much as they recount the history of the Lombards as he understood them, they must more closely reflect the intellectual climate of the Carolingians and the changing attitudes to poisoning that were already developing as the reform movement gathered speed. So in that first written law code of the Langobards, the Edictus Rotari, issued about 3/4 of a century after the Lombards arrived in Italy, in 643 CE, we have 4 laws addressing poison directly. Skip. The Lombard laws on poisoning begin with Edictus Rotari 139 through to 142 and focus on plotting, injuring and killing, and then with variations according to whether the perpetrator was free or enslaved. And as I've argued in a previous preliminary study of these 4 laws from the Edictus Rotari, poisoning is not addressed separately from killing by ordinary means because it's considered morally worse, or secretive, or nefarious, in contrast to how it's treated in later legislation, but instead it's addressed individually because of who the laws imagine could commit such a crime, which is to say, not just free men, but also free women and enslaved men and enslaved women as well. It is an equal opportunities crime as far as the Lombards are concerned. So the first, Rotari 139, on preparing poison with intention of giving it to another person to drink, sets a 20 solidi compensation, which is equal in value to about 90 grams of gold, and which is equal to the compensation set in Edictus Rotari number 10 and 11 for conspiracies to kill using more ordinary means. So in terms of restitution for plotting to commit a poisoning or to kill someone by any other means, it's the same punishment. And the law, in fact, even includes a statement to that effect written directly in it, which is incredibly useful from the perspective of a historian of law. Thank you, Rotari. Unlike the laws on conspiracy by ordinary means, where the perpetrator is identified with the somewhat neutral phrasing "si quis," if any man, however, the laws on preparing potion are more specific, beginning instead with the words "si quis homo liber au mulier," if any free man or woman. Like I said, setting the restitution at the same value. That attitude continues as we move through the laws, but it does get slightly more focused with each one. So in the next law, Edictus Rotari 140, we address the situation where poison is actually given to the victim to drink, but they survive, which must have been pretty horrible. It's comparable. Perpetrator is again given in terms of their class and gender, but it's now been reduced from liber homo o mulier to liber o libera. Just condensing the words there, but with the same intent. Compensation for the crime here is set at half the pretium, so half the worth of the victim. That is, half of the amount of weregild that would have been paid, would have been awarded had they been killed. Non-fatal poisonings are valued in proportion to the life of the victim, therefore, as calculated in monetary terms. Moreover, so making a direct comparison between injury with the other injury by poison with other types of injury is a little bit harder because obviously there's a lot of different injuries that a person can suffer from in the law code, from the loss of a little finger all the way through to losing eyes and everything, and they're obviously all valued differently according. So, like I said, a direct comparison can be a little bit awkward. So I'm just going to sketch this roughly rather than spending 2 hours going through every single injury and seeing how it compares against poisoning. So just to name a couple of potential wounds of similar proportion. Ambushing and beating a freeman is set at half of the pretium as well. So giving him poison, not killing him, is the same as ambushing and beating him up. However, if you tie him up as well, then that's even worse because that goes up to 2/3 of the weregild. Gouging out the eye of a freeman is also set at half of the pretium. But if he's only got one eye already and it's his last remaining eye, then it goes up to 2/3. Cutting the nose off of a freeman is set at half of the pretium as well, but cutting off the ear, only 1/4. Cutting off a hand, half of the pretium, but just paralysing the hand but not actually severing it, then again 1/4. So it kind of gives you a rough idea of where they're putting these things in. But I think there needs to be a lot more analysis of that for it to be really meaningful and useful. But what's probably the most important takeaway here is to say that the proportion is being set in relation to the life of the person rather than as a finite value. So, it's putting an extra rhetorical personal level into there. Poisoning is still in proportion to a person's life, just like gouging out an eye is, or cutting off a hand. And then in the next law, we get to when the victim actually dies. Here, however, interestingly, the law shies away from naming the class and gender of the perpetrator, and we are once more back to that general si quis. So the question arises here, of course, as to whether the law still included the scope for the perpetrator to be a free man or woman. Or, if, as I've argued earlier elsewhere, the lawgiver's view of poison as an equal opportunities crime simply crumbled when faced with the thought of a woman actually killing. Perhaps there are still some things that the Lombard lawgivers didn't really want to imagine. But what matters here, though, is that the compensation for killing with poison is set the same as for killing by any other ordinary means. That is, equal to the victim's pretium, per Edictus Rotari 11 and 12, as previously mentioned. Before examining the intricacies of intent behind a killing, however, whether by poison or other means, we should quickly mention the final law on poison in the Edictus Rotari, which is number 142, which I'm not going to go into too much detail, but this is basically addressing the situation when the perpetrator is a servus or ancilla, an enslaved man or woman, and the poison is administered with the victim either living or dying. Preparation with intent is not included here. And with the specific words of Edictus Rotari 139, it can't be assumed to be covered there either. So most likely, I think, is that the preparation of poisons, perhaps for vermin control and so forth, may have been such an expected part of many enslaved people's everyday duties that trying to extrapolate when intent was being, intent to poison maliciously was included was just not viable, so they just skipped it. That, or they just thought that enslaved people couldn't plan ahead. There's always a lot of chauvinism underlying attitudes to the enslaved. However, the overall compensation to be paid remains the same, determined by the pretium of the victim. And the reason that enslaved perpetrators are being addressed in a dedicated law, however, is firstly, the law stresses that it's not them who pays it, it's their lord, of course. A detail normally assumed to be true for all such situations is not always made explicit, so the fact that it is named here may be important. But secondly, also, the law also includes an unamendable death penalty for the enslaved poisoner. That's to say, the law explicitly states that the life of the enslaved person cannot be redeemed for a financial payment, but they must always be killed for having committed the crime, whether or not the victim dies or survives. The value of the enslaved person, however, is removed from the amount of compensation which is owed, which is to say that an enslaved person killing another enslaved person of similar rank basically gets killed without any monetary handover. So we could argue here on the one hand that this unamendable death penalty does emphasise that there's a nefarious attitude to poisoning as a crime, but there's no comparable statement for an enslaved person who kills by ordinary means, and other crimes with a death penalty for men, such as theft, remove it in the case of women, regardless of whether they are free or enslaved. On the other hand, the explicit inclusion of a death penalty here for enslaved people draws greater attention to the fact that there is no death penalty for the free perpetrator, and we should perhaps argue that the interpretation and expectations of poison as a crime are far more determined by the social class of the poisoner and effectively create multiple legal attitudes to the crime, even within the Lombard laws. So I'm going to step back from poisoning for a moment and consider the broader scope of intent of the perpetrator within the Lombard laws, because obviously that's needed to put some of this into a bit more context. So on the surface at least, the Lombard laws, as with most of the Leges Barbarorum, give relatively little emphasis to intent. As Carlo Calisa observed, writing from a perspective that imagined poisoning as the most nefarious form of killing possible, and assumed that the Lombards must have felt that way really, even if they didn't get around to saying it, for killing to constitute a crime, it must be an unjust homicide. It was not thereby necessary for it to have been committed with wrongful intent, for an involuntary death might also be punishable in the same manner. Rothar's laws condemned equally to the payment of the widregild one who caused another's death by preparing and furnishing a poisoned drink for the offering of a toast, and one who unwillingly brought about another's death. The distinction between the two classes of homicide only came later. This, however, is something of an oversimplification. And even within the Edictus Rotari itself, we actually have three main levels of killing that are outlined, or four if we include accidental deaths from things like lightning, but we'll ignore that one. So we have deliberate killings. Deliberately killing another person and publicly admitting to it is the main type of killing addressed in the laws. And it's the type, effectively, which is being outlined in Rotari 141 when it's done with poison, or in 11 and 12 for killing by ordinary means. As Calise notes, and I mentioned before, in both of these laws, the restitution is the same, pretium or wedregild of the victim. But then we have morth, murder, secret killing, which denotes a particularly nefarious type of killing, and is described as such, in which the perpetrator either made some effort to conceal their involvement in the act or to hide their victim's identity or the body itself. Probably it focuses primarily on the body itself. And here, the compensation due is set at 900 solidi, so about 4 kilograms of gold, for a victim who was a man, free man, or an enslaved man, or an enslaved woman. That's 3 times the weregild set for the highest ranking of Lombard freemen, which were set at 300 solidi, and more than 56 times the pretium set for the lowest rank of enslaved field worker, who has a humble pretium of a mere 16 solidi. Free women are not named in the laws on morth, primarily because to kill a free woman deliberately in the Lombard laws already has a compensation of 1,200 solidi, and it would be kind of redundant to say if you kill a free woman openly, you pay 1,200 solidi, but if you do it in a really evil way, then it's only 900. You know, I mean, the Lombards are misogynistic, but they're not that bad. Where are we? Like I said, so for free men, enslaved men and women alike, committing morth against them results in that same 900 solidi compensation. Morth in the laws is described as homicidium in absconse, killing in secret, a type of killing which we would really ought to be tempted to assume would encompass poisoning. But as I said, The actual compensation set for poisoning the Edictus Rotari means that Lombard lawgivers did not think of it as being an inherently secretive act. Otherwise, it would have been established as the equivalent to morph. Conversely, it suggests that if poisoning were committed in a secret way, then it would then become classified as morph instead, but it's not an inherent automatic assumption within the law. And then if we go to the other end of killing people, we have accidental and negligent killing, of course, addressed in Rotari 387. And this is the law that Carlo Calise overlooked when outlining his statement that there's no distinction between the different types in the original Lombard laws. But what we actually have is a statement that for a negligent killing, yes, the compensation is the same. It's still the full weregild. But in this particular case, there's no requirement for the faida, for the feud, to be pursued between the two families. Now, so faida, feud, is a state of enmity. In the old days, we used to think faida literally meant just the violence, like, that classic kind of the Vikings TV sort of programs and things where we get blood feuds between families. Yeah, there's a little bit of violence in there, but primarily it's a social and legal condition of enmity where you're not allowed to enter into contracts and friendship and situations with the other people. You can't even sit down and drink with them, basically. So it's a much deeper degree of dispute, which only occasionally bubbles over into violence. More importantly, rather than the faida being an outdated legal institution, which is slowly being replaced by the new system of compensation payments, which is kind of how the early 20th century scholarship saw the two systems, modern scholars now understand that the faida as basically the means by which you use to pursue justice. So rather than going, faida is being replaced by a thing of compensation, and we're going to have money to stop people just beating each other up on the streets and the violence just escalating. Instead, we use faida to get the other people to agree to go to court and to make a peaceful settlement. So they work hand in hand. So violence and feud are not synonymous, but also feud and compensation are not antinomous, aren't opposites either. So, should the killing have been accidental, Rotari's law outlines there's no need for that social and physical enmity of the faida, and only compensation should be paid. The compensation may be of the same value, but with the larger obligations of faida that a deliberate killing would have entailed, the overall repercussions for the actual families involved must have been significantly different, even if they don't look it so much on just the very brief law code. Moving forward 3/4 of a century, we come to the Lombard king Liutprand, who made a significant number of additions and amendments to the Lombard laws throughout the course of his reign, issuing a further 150 or so laws in about 16 different legislative sessions from the 712s to the 730s. And in the 720s, he explicitly expanded the legal framework on intentional killing. So the first part of Liutprand 20 introduces the new element framework, killing in self-defence. Here Liutprand states that the restitution will be just as it had been in Rotari's time, that's to say paying the full pretium of weregild of the victim. So Liutprand 20 begins by assuming that killing in self-defence was already covered in that general statement of if you kill anyone else intentionally. But then the law flips on to come down to deliberate killing, stating that now the perpetrator loses all of their property, whereas before it had been just paying the weregild. The heirs of the victim still receive the weregild, and the rest of the money left over, assuming that the perpetrator had more property and value than the pretium that was owed, then gets split equally, half and half between the heirs, and the other half going to the royal court. So, most important thing to remember there is that where before restitution was being made horizontally between the parties involved, the king has now got a finger in the pot and is also, has an interest, makes it worth pursuing and getting people to courts and getting killings over and done with. And perhaps now we can see faida being pushed into the background a little bit more as compensation is suddenly in the king's interest. The question, though, that raises with that change in attitude to deliberately killing is, how did it affect poisoning? And the answer to this one is quite significantly, and hopefully you'll agree with me, quite entertainingly as well. So 10 years later, in 731, Liutprand issues another law directly addressing poisoning as a response to what had happened to the knock-on effects of this law from the 720s. Turn over the page too far. He begins with a short narrative, incredibly useful of him, outlining exactly why this new law has to be introduced. Some men, he observes, when faced with the death of a relative by old age or illness, have instead been accusing wealthy neighbours of having deliberately poisoned grandpa, basically, and then proving this false accusation in the court through a judicial duel. It's an incredibly good way of robbing your neighbour if you've got enough frail elderly relatives. And you're good at fighting. So Liutprand goes on to clarify and reiterate the legal process for pursuing trial by combat, stating that the accuser and his oath helpers, for which there may have been as many as 12 of them, all have to swear an oath on the Gospels that they have genuine belief in the accusation being made. Doesn't sound like a major hindrance to us, but where oaths and honour are as highly valued as they are in Lombard society, it probably stopped a lot of false accusations. Still, by this point in his reign, Liutprand is becoming highly dissatisfied with the outcomes of trial by combat, stating that he has heard many instances where later evidence proved that the person found guilty in combat was actually innocent. And notes a little wryly that it's quite difficult to work out and interpret exactly what God intends by the outcomes of these trials of combat. He sort of laments, however, at the same time, that because of the weight of the Lombard custom and how important trial by combat is for them, that he's unable to change this law. So we're stuck with it. So if you can't get rid of the law that allows, or the custom that allows trial by combat, the best thing you can do is change the restitution. So now the compensation owed by a person found guilty of poisoning in a judicial duel is reduced once more to just the pretium of the supposed victim. And I haven't checked this to be absolutely certain, but I think this might be the only legal system in the entire Middle Ages where killing by poison is now effectively labelled as being less serious than killing by ordinary means. In all the other ones, it's either equal or worse. But Liutprand managed to make it less serious. However, I don't think that was his real intention. It's simply a byproduct of assuming that an accusation of poisoning was almost certainly still false in reality. So he appears to have thought of poisoning as being a very rare and very unlikely crime, regardless of what the outcome of a trial by combat may have suggested. So let's move forward past the Frankish conquest of the kingdom and into the Carolingians. As I noted earlier, Lombard law remained in use in northern Italy, but it was being supplemented by Carolingian capitulatory legislation. I don't want to go into great detail on the Carolingians here, partly because time ought to be an issue, but also because the capitularies addressing poisoning by the Lombards are admonitions to bishops about how they ought to be preaching against it, but they don't actually change the legal framework beyond saying it's evil. But just to very quickly summarise them, because it would be incomplete without, the two main pieces relating to Italy include, firstly, the Charlemagne's infamous Admonitio Generalis of 789, actually issued from the palace in Aachen, but for the empire as a whole, so is equally relevant to Italy. So I've included it here. In this, veneficia, poisoning or poison magic, is named as one of the sins that will prevent people from going to heaven. And the list of sins itself is a quote from the biblical book of Galatians, book 5, chapters 19 to 21. And even more interestingly, the Synod of Pavia held in 850, in which it's reported that traditions of using pestilent stirpes, plants or roots, are named alongside lingering remnants of other magical practices, and recounting that some of these practitioners are veninariae, so female workers of poison magic, and through their art it is rumoured that many people have been killed. While Liutprand thought that poisoning was pretty rare, Charlemagne, or no, not Charlemagne, whoever was underlying this synod at Pavia, which I haven't noted, I do apologise, thought it was an incredibly widespread problem, at least so the rumours would have us know. But let's return to the Lombard laws themselves. And I think the important thing to remember is that while these capitularies are doing something very, very different, the way that we know so many of them is through exactly the same manuscripts. You know, they're copied into the same law books, both within Italy and outside. You'll have law books that have one or more of the Leges Barbarorum and various capitulary collections. So, you know, they're still being treated in a far more similar way to each other at the time than we might think when we're cataloguing them and categorising them in the modern day. And so a lot of those things where modern scholars say, oh, but should we really be looking at the capitularies, can probably be ignored because the people at the time were. So ignore previous me who said we don't need to look at it now, and wait for me to publish something about it. Anyway, so I want to jump forwards in time even more, into the 11th century. Like I said, through that period between the 9th century up until now, more law books are still being produced. But at some point towards the end of the 10th century, a new textual version of the Lombard laws was produced, edited in the modern day as the Liber Papiensis, the Book of Pavia, because it's assumed that it was produced in the Lombard capital, or the former Lombard capital of Pavia. And it was probably produced by and for judges who were being trained in the law school, or the nascent law school in the capital there. And it was probably produced as a convenient source for these judges to check the laws when they were being deployed away from the capital and away from the palace archives. Now, this collection isn't really a concrete text like we think of them in modern days from a philological sense, where we have an explicit redaction made by a person. It's better actually understood as an idea of how the laws could be produced, and which whenever you wanted a copy, you could reproduce from scratch just from understanding the principles. And basically what it does is it brings together a very closely focused view on the laws, getting rid of all the unnecessary stuff like narrative prologues and the details of why it was promulgated, just to say who did it and, you know, what they said. Oftentimes it doesn't even include when they said it, although the laws are arranged in chronological order. So the only meta information, so to speak, is basically the name of the lawgiver responsible, which will become important later for cross-referencing. At the same time, along with the laws, they also assembled a collection of Carolingian capitularies, specifically those which related directly to Italy. And these two volumes travel along together, and there's a bit of argument about whether or not they're a single law code or whether they're two different books. But that's completely irrelevant now, but it has obsessed me for too long. But the other thing that we get from this new collection is that the Lombardist legal scholars are using it to annotate and to expand on the laws. They're starting producing scholia for the exegesis of the legal contents, trying to clarify the meanings, trying to work out which laws override previous ones and which ones relate together, and how to build a bigger understanding of the entire legal context. And because the Lombard laws are often very concise and a little bit vague and have been looked down upon, to put it lightly, by some later scholars, they also needed to expand on some of those ideas, and they start beginning to look through Roman law to get ideas of how to better approach and understand it from the 11th century already. So, one of those manuscripts of the Liber Papiensis, now held in the National Library in Paris, was originally produced in or around Pavia itself in the 3rd quarter of the 11th century. It includes a collection of glosses and commentaries attributed to the judge Valcausius, who was active in the 1050s to 1070s. And this commentary has been recently edited in the modern day as the Valcausina. So within the Paris manuscript, there's a folio there, the laws on poisoning appear on folio 7 verso, so the 7th page on the back of it, and presented in the same order that they were originally issued, as we were discussing just now. So we have, very, very quickly, Vitari 139 on a free man or woman who prepares poison, 140 if the free man or woman gave the poison to someone else to drink and that person survives, 142 down to the bottom, 142 on the enslaved man or woman who gave poison, causing injury or death to their victim. And going back up slightly for the one I want to focus on, 141, when anyone, but a free man or woman, we've assumed, gives another person poison to drink and the victim then dies. So let's zoom in a little bit there. As we can see, got the main text in the writing window, so the ruled area of the page running across. And then we've got glosses and a diagram in the margin. Breaking down what we've actually got here, we begin with the main law itself from Batari. If anybody gives another person poison to drink, the one who accepts it dies, compensate the entire Praetorium according to the quality of the person. Following this, we have an addition. It keeps going, expanding, attributed to Valcausius, in which information from other laws has been incorporated into the main text. Each additional segment is marked with a pareth mark to divide the content into logical units, and the start of the insertions is also marked in the interlinear space with an A in this manuscript. In other locations in the manuscript, a triangle formed from 3 dots is indicated instead. Incidentally, the implications of this clear marking of Valcausius's introductions were soon forgotten or perhaps deliberately ignored. And in the 13th century, the Romanist Odofredo, notorious for his historical inventions, put a lot more emphasis to making Bologna as the point where the juristic revival began out of nowhere in the 12th century, and seeking to reframe and diminish the work of Valcausius and his contemporaries, ignoring his status as a judge and legal scholar, and instead referring him simply as a forging monk. Odofredo's opinions on the Lombardists are, of course, notoriously biased, and he happily echoes the opinions that were circulating in Bologna at the time, such as Boncompagno, and possibly even going back as far as Hugaccio, with their tired rhyme that the Lombard laws should not be called lex, but fex. That's the Lombard shit. Bologna really loved the Lombard laws, and I've had reviews on pieces when I've said, am I approaching these properly as legitimate texts? But we won't go into that complaint now. But let's, rather than looking down on the Lombardists, let's look at what they actually did do. So the first part of Valcausius' edition here clarifies the grammar, first making it clear who pays the composition, but also emphasising the role of the judicial duel or pugna. So it now reads, with the expanded part through, if anybody gives another person venenum, poison to drink, and the one who accepts it dies, the one who gave it compensates the entire Praetorium according to the quality of the person, if he is convicted through the duel. So it's brought those 2 laws together a bit more neatly. The next edition then incorporates Liutprand's doubts about the veracity of the duel as a means of proof, and adds si vero. If the accusation is true, however, then the poisoner should otherwise lose all of their substance, essentially linking back to that earlier law of Liutprand, in which it introduced a distinction between accidental and deliberate killings, or self-defense and deliberate. The final edition amends the compensation owed in the situation when the victim was a free woman, stating that the compensation due is instead 1,200 solidi, which echoes the values that we were discussing earlier in that conversation about morth. So here then, Valcausius' editions, for the most part, clarify the legal content by taking information from other laws directly into the main body of the law on poisoning here. Although I would argue he went a step beyond just bringing that information in with that clever solution to truth versus proof for a judicial duel. And by reintroducing the contents of Liutprand 20 after the summary of details from Liutprand 118, we kind of get an expanded reading, where Liutprand had issued the latter law on false accusations of poisoning explicitly to counter the problems that the former had introduced. Valcausius' careful inversion and the statement that if the accusation is actually true basically counters the limitations that Liutprand had encountered and tried to address. The next part that we have in the law is a placita, a sample plea outlining how the legal official would present the accusation in the court. This one is relatively simple compared to others in the Liber Papiensis, and if I'd wanted to demonstrate how the placita work, or how Walcausius Placida work, I probably could not have chosen a worse law. It's so simple. All it says is, Peter, Martin accuses you that you killed his father with poison. The crime. No. Thank you, Walcausius. But he did actually, in some of the manuscripts, get a little special poem which basically says, thank you, Walcausius, for making the laws clear to us. We couldn't understand them before. So clearly his students appreciated him. So beyond the typical use of Peter and Martin as the main actors found throughout Walcausius Placida, the addition of the specific relationship between Martin and the victim, his father, is also stressed, emphasising that the pursuit of justice is imagined here as being by the heir of the victim. Likewise, poisoning is being imagined as a crime between families. And Walcausius has not made any links, or not drawn any of the links, whether here or in the expanded commentary proceeding, to tie the law on poisoning to other laws addressing intrafamilial violence, such as when a son conspires against his father, or a woman is suspected of conspiring in her husband's death. So even then, there was a little bit more in Walcausius' brief Placida to consider, but as much from what wasn't said as from what was. The outer margins also have commentary added, some of which are tied to the main body of the text with metamarks, basically the footnote handles like we use in modern publications. And there, the gloss in the margins expands further, or in these cases, basically provides the reference to the law in question. I'll zoom in on them again a bit further. So for Retavi 141, we have 4, possibly 5 such glosses. The last gloss, this one here, may be for the law following. I can't decide yet. If anyone has any suggestions, please do let me know. So the first one provides cross-reference specifically to Lurtfran's laws on false accusations. Glosses providing cross-references are given in roughly the same style throughout the Liber Papiensis manuscripts, beginning with a majuscule P here with a cross line through it, which is basically the Latin abbreviation for per, signalling to the reader that the information can be expanded by, or in the case of Walcausius editions, is drawn from, the information in the referenced item. Other glosses found elsewhere in the law code, or in the Walcasina notes on it, sometimes include other information, particularly when we're informed that a specific law has been broken, rumpetur, that is to say superseded by a later law, therefore changing the legal context. The gloss here in the Paris manuscript doesn't have a metamark to actually tie it to a specific word or phrase in the main body. That might simply be an oversight of the scribe, as there is one in the interlinear space itself where we might expect to see it. It's quite easy, I guess, if you're doing it by hand, to forget to put the second footnote handle in. And it's literally positioned just before the reference to the accusation being proven by Joule in the text. The next gloss that we come to actually offers a branching diagram adding further information to the laws. Head of the diagram repeats the somewhat vague si quis of the law, which then appears to clarify with the supply of 2 subheadings beneath it. Liber, that is free, on the left, and libertas, freed, on the right, and saying, therefore, that this law applies equally to free people and to freed people. The specific wording of the gloss in the manuscript only includes the stem of the word, and arguably, therefore, could be read as libera and liberta, free woman and freed woman respectively as well. Although I find it a bit unusual that the scribe didn't write out each identity category specifically, when they're normally quite thorough in all the other glosses. So there may have been some removal here continuing of the potential for the woman to be the poisoner as well. I just said that. Should also be noted the metamark tying the gloss to the main body of the law, a reverse C with a line through it, is in fact positioned above the word alia, another. As such, it could be taken to imply the identity category of the victim, but I think that's just a positioning and a misreading thing, and we'd have to then ask why are enslaved victims excluded. However, overall, the sequence heading in the gloss strongly suggests that it is the perpetrator who is intended here. Again, though, this remains a work in progress. So the third gloss, again cross-reference, and again tied to Lurtfran's law, this time number 20, in which Fess set out the change in compensation due for deliberately or negligently killing a person, as discussed previously. So again, it's just tying to the law in question. And then the next one again provides confirmation in the law code for the additions made by Valcausius in the integrated commentary, in this case regarding the compensation owed for the killing of a free woman or girl, that 1200 solidi that keeps cropping up. Again, there's no meta mark here, but again, that seems to be an oversight by the scribe, and this time there is one again in the main body. And then the final gloss, moving through to the mid-11th century, and tying to that capitulum of Henry II that I briefly mentioned at the beginning. What's going on here? There's a meta mark in the gloss, but there's none in the corresponding space in either this law or the one following. So it's very difficult to work out where it's meant to be. The law, or the capitulum here, is near contemporary to the Liber Papiensis manuscript. Now, this capitulum was issued in 1156. The manuscript dates to somewhere between 1150 and 1180, probably the 1170s. And this capitulum of Henry now only survives in the Lombardist law books. We don't have any other copies of it. Technically, the legal contents of this capitulary that we're about to look at should override and replace everything which is included in Vitari 141 and 142, making much of the elaboration given in this manuscript and others of the Liber Papiensis obsolete. Normally, when a law has been made obsolete, that's marked in the manuscript by just putting a theta sign next to it. So, it's been copied for reference, but it's no longer considered to be in force. That hasn't happened in the case here. So I want to conclude, finally, by taking a look at what's actually in that capitulum and how poisoning ends in Lombard Italy or post-Lombard Italy in the Ottonian period. The capitulum builds, like the Carolingian ones we skipped over briefly before, by placing poison within a broader context of the acts of the impious, that is, the wicked, and how they are deserving of retribution. And then goes on to state that we have heard many rumours of deaths caused by beneficio, poisoning. A plaintive cry of pro dolor, for shame, inserted here into the capitulum stresses the emotive reaction to these rumours, and we're as far from the unemotive framing of Rotari as we can get. Moreover, the law here gives poisoning as the one explicitly named form of diverso genere furtive mortis, various kinds of secret killing. Neither Rotari nor Liutprand had considered poisoning to be inherently secretive, but here in this capitulum of Henry II, these two threads are, finally perhaps, brought explicitly together. Unlike the Carolingian capitulum, however, this one goes on to outline a response in the legal framework to such killings against anybody who kills by poison or other various means of secret killing, or even consents to such an act being done. Firstly, the law now introduces a death penalty for the crime. While Rotari had included a death penalty for enslaved poisoners, now we've extended that to free perpetrators as well. Although we should remember that in the glosses of the Valcausina, as just discussed, this element is not stressed. Henry's capitulum then goes on to state that the perpetrator also loses all of his property, as we saw with Liutprand. That is to say, there is now no inheritance for the heirs. Obviously, the person who owned it is dead, or the poisoner is dead. The removal of the entire substance, of course, like I said, reflects that law by Liutprand, which was then overwritten a decade later. When Valcausius picked up this point and reintegrated it into the law, he could easily have done so simply by citing Henry's capitulum here. That he chose not to remains a point for further investigation and consideration. Hopefully I'll find an answer soon. But as that commentary and law was written in the Paris manuscript, it appears to still keep the death penalty away from the free perpetrator, despite what the new capitulary legislation had proclaimed. Rotari's laws are still allowing a free poisoner to survive. But of the property confiscated from the family of the perpetrator of the poisoning, Henry II now sets a widrigild or compensation equal to £10 of gold. Incidentally, like the 900 solidi mentioned before, that's also approximately 4 kilograms, and therefore practically identical to the compensation set in the mid-7th century by Rotari for murder, almost 500 years earlier. And like with Liutprand 20, any leftover property that had belonged to the perpetrator was again to be divided equally between the heirs and the royal fisc. So, it's worth noting that Lombardist legal studies did not end with the Liber Papiensis. In fact, this is really the high point, but then it continues in a new form through the university, law schools, and glosses and commentaries produced in Pavia diffused out into other manuscripts, and in the late 11th century, another variation of the laws was produced, the Lombarda, in which the chronological arrangement of the laws and capitulary collections which make up the Liber Papiensis was broken, and there instead was systemized into thematic legal titles divided into 3 libri, effectively criminal, civil, and ecclesiastic law. Such an organization of legal materials is hopefully quite familiar. Within this new arrangement, the continuous reading of Vitari's laws on poisoning, from preparation to administrating, injuring, and killing, in that echo of Sulla's Lex Cornelia, was broken, and the laws were split, with 139 and 149 now going into a title on conspiracy, and 141 and 142, along with Liutprand and Henry's laws, into a larger title on murder, homicide. So the law text became the one studied in the universities across the remainder of the medieval period. A law text is transmitted with updated versions of the older legal commentaries, such as the ones we were discussing just now, along with new ones produced by university magistry across the 12th century until the Glossa Ordinaria of Carlo di Tocco was established in the early 13th century. Again, a subject I hope to return to. For now, what I hope I've presented is an interesting view of the early medieval source materials of poisoning up to the rise of Lombardist legal studies. And I'd be very happy to answer any questions regarding those and to try and point towards what I think comes next, or at least to throw my hands up and say that's work left to be done. But overall, what we're seeing in the Lombard laws across the early medieval period are developing attitudes to poisoning that, as it continued to be revised and reinvented. The interrelationship of poisoning with other means of killing, inflicting injuries or plotting are highly informative as to how the Lombards and early medieval societies as a whole not only understood poisons and acts of poisoning, but also how they understood those broader contexts in which they could be contextualized. All of these facets come together to reveal far more about the legal framework and the legal imagination of the lawgivers than just comments on, is poison magic? Why couldn't they express the inherent secrecy and nefariousness of this as a crime? Thank you.
Thank you very much. Are there any questions from the audience? Don't be shy. Our usual question givers left early. I'm not sure why, but I think there's something going on in Amphitheater 5, so they might have rushed off to it. But either way, while the students are thinking, I'd have maybe 2 questions.
Excellent.
If that's okay. Maybe 3.
Brilliant. I hope I can answer them.
One thing, when you mentioned the sudden end, we have a question online. Someone raised their hand.
Oh, and lowered the hand. Yeah. Oh.
Do you want to go first?
Oh.
Yeah, sure. I mean, I don't know if you can hear.
Yes, hear you.
Okay.
Yeah, sorry. I wrote the question down, but I can also read it. Can you tell us something more? Yeah, sorry. Can you tell us something more about how Edictus Rutaris influenced the church law, the canon law of the Middle Ages? And did the Roman law and what extent had the influences Legis Barbarorum of that part of the Europe? I'm just curious because I am more into canon law myself, so I'm just interested how it had. Was there any correlation between these laws and the canon law of that in that part of Europe in the Middle Ages? Thank you.
I can't answer the first half of that question because I know very little about canon law, I'm afraid. Apart from to say that in Liutprand's laws, there are a number of statements for very specific crimes that say that not only should the perpetrator pay the secular restitution, they should also commit penance according to the canons. I mean, that's the only link I have on that one, so I have to apologise there. The route through which Roman law influenced Legis Barbarorum, on the one hand, there's a huge amount of probably oral tradition, as I was mentioning at the time, where these Germanic groups were already engaged with incorporating Roman ideas and bringing them into their law codes. But we also have, in the very early medieval period, particularly sort of the 5th to 6th centuries, we have what are called the Vulgar Laws, or the Leges Romanorum, like the Breviary of Alaric and the Lex Romana Burgundionum, which are basically law codes assembled and issued by early medieval kings, but for the Roman population with them. And they are normally epitomes of Roman law. A large quantity of the Roman law is just directly brought through that way. So we have a literal direct transfer as well. And then some of those Leges Romanorum fed directly into into the Leges Barbarorum. The instance that I quoted just now at the beginning about the grounds for divorce in the secular Burgundian laws is directly coming from the Roman laws, with just minor rewritings and so forth. Does that help any?
Yeah, it helps a lot, actually. Thank you very much. I am doing my research on my own, but this is setting me on the right path. So thank you very much, Professor.
Oh, fantastic. Sounds interesting. That's helpful.
Okay, so first you mentioned the sudden change in the Carolingian period of poisoning being seen as anti-Christian and very evil and nefarious and all. Is there a particular moment, like an originating thought, someone very important qualified it as such, and then we see everyone repeating it? Or
I think it's an accident, personally. I don't think it was a deliberate thing that they were trying to do until it picked up speed. I think it came through as part of the broader Carolingian reform process, where they're bringing everything through, and this new attitude to poisoning came through. Because if we look through the older Christian texts and saints' lives, we see poisoning being expressed in its biblical form from the beginning in relation to saints. We have particularly poison being used as a metaphor for sin and for evil and for heresy. And then what the Carolingians are doing is just expanding that idea outwards into all elements of society, as the Collectio keeps doing when they're bringing things through. So I need to keep looking at this, and this is part of my proposed project for the future, to try and confirm it. But as far as I can see, it looks like it was kind of an accident that just came along with everything else. You know, they're trying to reform society, and this attitude to poisoning that began as attitudes to evil being brought through, and that metaphor just expanded out to literal poisoning and overrode it. But at the same time, I think there may be something going through with that crossover between magic and poison that's already in some of the older laws, especially the Frankish ones, and that integration was there already, and they'd already got something to build on and to work up from. But I don't think there's a specific moment where somebody sat down and said, we need to make poison evil. Although the flip side to that, of course, is that a lot of the Carolingian intellectuals were themselves primarily bishops and priests and deacons and church officials who were contributing to the production of law now, rather than, like in the case of the Lombards, where it had been kings and judges and other legal officials. So it could simply be that they were used to thinking of poison in those terms because the main text they were used to already had it. So it may not have even been, we thought of something new. It may have been, why didn't these people do it this way already? Or they just kept doing what they always did, and because of the new textual area they were working in, it expanded. But like I said, that's speculation, not even hypothesis yet. So I need to keep working on that. But yeah.
Okay, thank you very much. Second, a general thing, since you said, so not just in Lombard laws. In some laws, it's prescribed related to magic and all, it's more or less the same thing. And in other laws, it's just a means of murder.
Yes.
Is there a noticeable correlation between how it is prescribed and how it is punished? So is it always punished more severely in those laws that treat it as related to witchcraft, and just punished as ordinary murder in those others?
Nope. It's, the main example where it's linked with witchcraft is the Salic laws, where it has exactly the same punishment as killing by ordinary means, which implies that in the Salic laws as well, magic isn't any worse than using a sword on someone, which I don't think is what they intended, but that's how it comes across from that perspective. So there's no division there. And I think what also needs to be considered is that with the Lombard laws, we assume it means poisoning in the most literal sense without a magical element, but nobody's really given a convincing argument for why the Lombards get to be just pure poison without a magical side to it, and all the other law codes are kind of a double crime of poison magic. And I suspect that's because of the Lombardist legal scholars' later role in legal studies, their proximity to Italy and the fount of proper law, and the idea that these people must be more rational just by association, and therefore there can't be magic in it. But nobody's actually proven that there isn't a magical element to the Lombards' understanding of poison. Or at least nobody's proven it to my satisfaction yet that I've seen. So yeah.
Okay, thanks. And finally, why is there no difference between the punishment for Morse regarding the victim's status? Why is it 900 regardless of whom you killed in that vile way, and not 3 times more, for example, than the victim's spezi?
3 times more would have been a really nice, clear way of expressing it. I suspect it's 900 because Morse is such a big crime that status is simply forgotten at this point, apart from if your status already puts you beyond it if you're a free woman. That's the only explanation I've got for this one. The other one is that Lombards use 900 solidi as a kind of rhetorical statement. You know, if they say 900 solidi, you can imagine them banging their hands on the table while they're saying it, you know, and to drive the point home. And I think it's a number that has greater weight than its value. And obviously its value is 4 kilos of gold. But yeah, but it's a good question. And
okay, thank you very much. Are there any more questions? If someone wants to ask something and isn't confident in their English, I can translate. Don't worry. If not, then thank you once again.
I'm very sad that nobody asked what were the actual poisons that they used. I was expecting that question and left a hole open for it, but it's just to say we don't know.
Okay,
plants.
What were the poisons that they used?
Plants. That's all they say. Isn't it annoying?
Yes. Thank you very much.
Oh, I forgot the